Thank you. I'm Megan Hunt, M-E-G-A-N-H-U-N-T, and I'm here to present LB1029. You may not know, and I recently learned, that there are no legal protections against harassment and discrimination for employees in Nebraska if they work for an employer that has 14 or less employees. Federal protections only apply to employers with 15 or more employees, and our Nebraska law, the Nebraska Fair Employment Practice Act, mirrors it and has that same 15 employee threshold. This means that if your employer harasses you and you work for a small business, you're not legally protected and there's nothing you can do to bring legal action against them. What prompted me to look into this issue and eventually bring this bill is a conversation that my office had with a constituent who has experienced ongoing sexual harassment from her boss, who owns the company she works for. This man made repeated crude and sexual comments, groped her and made unwanted body contact, contacted the employee after hours and made threats to her in her job if she didn't put up with it. This woman actually tried to file a case against him and explore her options for what action could be brought against him, and came up empty-handed. Multiple attorneys she consulted advised her that she didn't have a case because due to the employer having fewer than 15 employees, his behavior was not prohibited in state or federal employment law. She also told me that comments the employer made indicate he was actually aware of this and exploited it, harassing multiple female employees, knowing that his actions weren't illegal under employment law. This particular case stuck with me and was egregious enough to prompt my office to conduct some research into the issue and introduce this bill. While this woman's case is an especially serious example of why we need to change our law, it's not just about her, because it's something that should be done for all workers in Nebraska. It doesn't make any sense that workers in Nebraska are only protected from harassment or discrimination from their employer if they end up working for an employer that has an arbitrary 15 or more employees. It's my understanding that our Fair Employment Practice Act was drafted this way to mirror federal laws, and also because there may be arguably some components of FERPA that would be more burdensome for smaller employers to comply with, that might require more money or more record keeping or more employees to help or things like that. But what we landed on with this approach for this bill is a moderate step that applies harassment and discrimination protections to those smaller employers as well as the larger ones, so they're all equally protected. My office consulted with the Reviser of Statutes office on this very extensively, as well as the Nebraska Equal Opportunity Commission, and we agreed that the language in this bill was the simplest way to accomplish our objective. The Fair Employment Practice Act is fairly complex, and there's agreement that it was poorly drafted in the first place. We make the change by bifurcating employers into two groups, those with more and less than 15 employees, and applying just the anti-discrimination and anti-harassment provisions to both groups. All of the other existing requirements in the Fair Employment Practice Act continue to apply to the larger employers only. I don't know what legitimate arguments there could be for saying it's more difficult for small employers not to harass their employees. There's no good reason that employers with 14 or fewer employees should be free to discriminate against and harass their employees without penalty under this act. This costs employers nothing and requires no resources. They just have to not harass people. I'd be happy to take any questions.
Thank you. Are there any questions?
Oh, one other thing. May I add one thing?
Yeah.
There are 37 states that protect all of their employees, even if it's fewer than 15, including all of our neighboring states. So that's all. Thank you.
Thank you.
Thank you. I'm passing out something that's hot off the presses. The woman who came to my office and asked for the help, she was going to be here today, and then kind of at the last minute today decided she was afraid of retaliation and didn't want to come. But she sent me this testimony, and she asked that I share it with you. For the record, I won't read the whole thing, but this letter just details the nature of the harassment that she experienced. Verbal, physical, all of these things. And she says the harassment was ongoing for years, and although I needed the job, I was too stressed at work, or anytime I saw the person call me. And when I was at work, I had to answer the phone. but it might be the employer making another sexual advance at me. The employer would threaten to come to my home. He would text me at my other jobs or sit outside and wait for me. While I was working, I feared for my safety, as there was more than one entrance in the building, so I would block 2 of them so the employer would have to come in the front entrance. This is the kind of bill that it doesn't affect any business that's following the law, that's treating their employees with respect. And for the people it will affect, it's going to mean a great deal to them. And I think that that's the best thing we can do with our resources and time here in the legislature. And this is a really worthy policy, and I hope we can exec it out and find someone to put this on.